Thanks again for joining us today on our webinar focused on appearance discrimination issues, unconscious bias, with a special focus on the Crown Act. When we were putting our program together at the end of the last year, looking ahead to kind of cutting edge issues and in some ways that significant ways that the law is changing, and I'll get into this in a little bit in more detail. But as Ashley and I were getting ready for this, I was reflecting on how over the course of my career, and I guess Ashley, we can maybe just jump over to the introduction slide. I've been a labor and employment and OSHA lawyer, emphasis on OSHA, but I started as an employment lawyer back in 1995, so dating myself just a bit. And appearance issues really weren't or appearance really wasn't much of an issue. It was something that was largely accepted, that employers pretty much had near full autonomy in deciding, how employees would dress, how employees would groom themselves, hairstyles, jewelry, and even in many cases, weight and other kind of real personal aspects of folks' appearance. And that's changed quite a lot. And so we're gonna, we thought this would be a good topic to explore with you all. And kind of get into some of the nuances, how things have changed, where they're going. Ironically, we don't have, in a webinar talking about appearance, we don't have our cameras on, so you can't see us. I certainly would not look professional today. For those of you that have heard webinars that I've done in the past, I may sound a little bit different. I'm very congested. I'm recovering from COVID, so I will ask your indulgence and patience if I begin coughing at some point during my presentation. But concluding the introduction, I am based in Chicago, where I've spent the majority of my career after a brief stint in St. Louis in the mid-90s. I attended the University of Chicago and law school at the University of Texas. So I will let Ashley, or I'll turn it over to Ashley to introduce herself. I know she's got some opening remarks, and then we'll dive in.
Thanks, Aaron. So hello, everyone. As Aaron mentioned, I am Ashley Mitchell, and I'm an associate in the Chicago office, and I represent employers in both labor and employment and OSHA matters. So I advise clients on compliance with both L&E and OSHA work. And then as it relates to today's topic, I have done a number of handbook reviews assessing for compliance generally, but as well as it relates to potential issues with appearance discrimination. And so with that, I will go ahead and get into our agenda for today. We will start off by looking at how the EEOC and other fair employment agencies evaluate discrimination claims, and then looking at state and local jurisdictions which have passed or will likely pass Crown Acts, and then closing out today with proactive steps that employers can take and best practices to just generally avoid such claims. But before we get into the details of today's webinar, I want to start with a question. And my question to all of you listening is, what does professional appearance mean to you? And as you're thinking through that question and thinking through our theme today of appearance discrimination and unconscious bias, when I asked you that question about professional appearance, as you were thinking through your answer, it could have been informed by your profession, what area of the country you are working in. It could be potentially informed by when you entered the workforce. I know Aaron mentioned that he entered in the mid-90s. I entered in the, mid-2000s. I'm not really sure what we call that time period just yet. It could also be influenced by your race or your gender. So, for example, as we're thinking about professional appearance, professional dress for a golf pro or a tennis pro would look radically different than professional dress for a lawyer who's attending a trial or a hearing. Professional dress for an ER doctor, may look different for that same ER doctor when they're working in the ER versus if they are in court giving expert testimony at trial. And so as we are giving our webinar and thinking through my question to you of what does professional appearance mean to you and broadening it to your workplace, now and throughout our webinar, I invite you to curiously examine what you think professional appearance means and whether there is room to expand the image of professionalism and what comes to mind as you're answering that question. And with that, let's get into our webinar.
Thank you, Ashley. Yeah, and again, if cameras had been turned on, you'd see, and you go to our bio page, and you see that I and a number of my colleagues have beards. And when I started my career in the mid-90s, there may have been a lawyer at my first firm that had a beard. If he did, he was an outlier. I'd say probably even 10 years after that, I remember that the joke was if you saw somebody growing a beard at the law firm, that meant they were getting ready to give notice. They were leaving the firm because they didn't care what people would say if they grew a beard. And so again, talking about those shifting perceptions, the shifting views of what is professional, what is acceptable, and really kind of getting into I think the changing norms in society, and kind of re-examining what is, as Ashley said, what is professional, what is quote traditional. We'll talk a little bit more about that. And so what I wanted to cover for the next several slides, and we can kind of move to the next slide on Title VII, is I know that probably everybody who's listening right now is very familiar with the various employment laws, assuming you're either in-house counsel or HR professional, and you've heard all these, but you're familiar with Title VII, you're familiar with the ADA, with the Age Act, et cetera. But we want to kind of take a little bit of a different look at a few of them, and we're going to cover some basic grounds just to orient everybody, make sure we're all kind of on the same page and thinking about these issues, how the agency does, the EEOC and other agencies. We try to inject a few other kind of different thoughts or other ways to look at some of these questions. And then I'll conclude and probably spend the bulk of my time just talking about various appearance policies, considerations, some different number of interesting cases that we've tracked over the years, and give you all some food for thought. So I think obviously the probably the most significant, certainly the Fair Employment Law that I've dealt with the most over my career, Title VII, which applies, I'm sure, to all of our listeners, certainly anyone with 15 or more employees. I think I always consider it to be the broadest, right? It covers race, covers color, covers sex, religion, national origin. But within that, there are other concepts to be mindful of. So for example, ancestry. So employment discrimination based on one's racial or ethnic ancestry is prohibited. This can include, it's sort of an intersection, if you will, between race and national origin in some cases, but they're not identical. So for example, there could be discrimination against a Chinese American who's targeted because of her Asian ancestry and not because of her Chinese national origin. So in that case, she would have a discrimination claim based on race, not national origin. Certainly, there are physical characteristics that can form the basis of a Title VII claim. Someone who's discriminated based on characteristics that tend to be traditionally associated with their race. So it could be their color, their hair their hair, their facial features, and a number of other different considerations. In some cases, there are race-linked illnesses, right? So whether it's Tay-Sachs disease, which can be connected to people of Jewish descent, sickle cell, which can be primarily affects persons of African descent. Native Hawaiians have a disproportionately high evidence of or incidence of diabetes. And so for an employer that applies facially neutral standards or requirements that end up excluding treatment for conditions or risks that disproportionately affect employees on the basis of their race or ethnicity, that can lead to a claim. The employer would obviously have to show and produce evidence that the standards are based on generally accepted medical criteria. There are claims, I think one of the types of claims that we've seen more frequently or more becoming more common are claims of perception in terms of somebody not meeting or complying with the standards that are perceived to be or viewed to be typical of whether it's their race or their gender. There could be claims based on association. So discrimination claims based on association, where an individual perhaps is associated with someone of a particular race. Obviously, it would be unlawful to discriminate against a white person who's married to someone who's African American or has a multiracial child, because they maintain friendships or relationships with folks of a different race. I mean, obviously, these are claims that I think are very should be and are typically rare, but we do see them from time to time. Reverse race discrimination, as it's sometimes coined. I don't think that's it's one way to phrase it. I did try a case to a jury verdict in Indiana a number of years ago, brought by a white woman who claimed to have been denied a position working for a newspaper in northern Indiana, a position that was filled by certainly in my view, an obviously more qualified African American applicant. And one of the interesting issues in that case was that the employer kept the application period open longer than it normally did. And when this individual came forward, and this is all public records, I'm not sharing any of this, all came out in the trial record. When the woman came forward and talked to the editor of the newspaper to ask, what the status of her application was, she was told that the application had been received, and was informed that the company was keeping the application period open longer to see if a qualified minority applicants applied. Well, that was all she needed to hear, right? When she didn't receive the job, filed an EEOC complaint or charge. The EEOC ended up finding substantial evidence of discrimination based really on that one remark. And ultimately the case went to trial. We won. The jury was not out very long. I think because we were able to demonstrate that the person who was hired was indeed more qualified. But and there was clear law that in our favor that an employer can change the practice or the procedure it follows when filling a position in order to create diversity in the applicant pool, provided they ultimately hire the most qualified applicant. And so that is something for employers that are focused on fostering a diverse and inclusive workplace, that you can change how you can change how you source applicants or the process, provided again that you hire the most qualified applicant. It's something, if you do that, obviously in this case, being careful, and being clear how you're communicating that if you are doing that to folks that are involved in the process, and making sure that the process that you follow ensures that you're hiring the most qualified person. Something happy to discuss if anyone has further questions, down the road, but it is something that I thought was worth sharing. So moving on to the next slide and kind of building on what I talked about with towards the end of this prior slide. In addition to disparate treatment, there is, of course, the potential for disparate impact claims. So disparate treatment, very simply, is where someone's membership in a protected class, a protected trait of theirs, is the motivating factor and kind of the but-for cause, if you will, of the decision to not to hire, to terminate, to discipline, etc. It's essentially, that's the motive. It can be racial animus, gender animus, etc. It can be based on stereotyping, making assumptions about people. Obviously, I think as everybody, listeners are well familiar, yielding to the preferences of a customer who doesn't want to be served by somebody of a certain race, or doesn't want their case, that something handled by a member of a certain race. Obviously, that none of that would be justification for to yielding to that customer's preferences. On the other hand, disparate impact claim is where you have a neutral policy or practice that has a negative impact on one or more protected groups. You tend to see this more often in hiring situations, for example, if you have certain criminal background requirements that may not be job related, and other policies or procedures that tend to impact one group over another. And obviously, depending on the nature of those policies and procedures and the evidence that would be adduced in defending them, they're difficult claims to prevail on for the claimant, but they can also be difficult and complicated claims to defend for an employer. If you look, then moving on to the next slide, in terms of disparate treatment claims, in cases where the charging party is trying to prove disparate treatment, or I should say, I'm sorry, disparate impact, there are a number of different kind of policies or procedures that may be subject to challenge, and ones where you may, based on the facts on the ground, the realities in your workplace, where you may need to consider and evaluate, again, your recruitment practices, the criteria that you follow, whether it's for hiring decisions, promotion decisions. Similarly, obviously, with respect to layoffs or terminations, group reductions, having certain policies or procedures could certainly disparately impact older employees, for example. And again, here, even with what we'll be talking about in more detail in a bit, appearance or grooming standards, certainly those types of policies or procedures can be challenged. I think both on a disparate treatment basis, depending on how they're applied or carried out on an individual basis, but they have the potential to impact one group more than another group. So you need to be mindful of both issues with respect to appearance and grooming standards. Education requirements, right? If you have positions, and a lot of these, obviously, it can come down to whether it's job related and consistent with business necessity. But we tend to see legacy requirements that may have been adopted at one point that remain in place, that perhaps should be changed or modified in some way. Related to that, similarly to education experience requirements. And last but not least, employment tests that again, depending on whether they are necessary for the position, can have a disparate impact on different groups for a variety of different reasons. So moving on to the next slide, please. Thank you. Focusing first for a minute or two on race and color discrimination claims. It's interesting to note that I think we're also accustomed to dealing with these types of claims and policies and procedures that are intended to prevent them. But the Title VII does not contain a definition of race, or does it define color? And the EEOC has not adopted one. So when the federal government, as I'm sure most, if not all of you are familiar, when the government gathers data on race and ethnicity, the Office of Management and Budget has identified 5 categories: so American Indian or Alaska Native, Asian, Black or African American, Native Hawaiian or other Pacific Islander, and white. And then one ethnicity category, which is Hispanic or Latino. And OMB makes clear in its guidance that that these categories are quote social political constructs and should not be interpreted as being genetic, biological, or anthropological in nature. I've seen, interestingly, a couple of interesting cases that get into for Jewish individuals this debate of people that view it as a race, others that view it as an ethnicity, others that view it as a religion. So there are complicated issues that can come into play here. As far as color, as I said, neither the commission has not defined it, but it typically, its commonly understood meaning is pigmentation, complexion, skin shade, or tone. And so color discrimination occurs when a person is discriminated based on the lightness, darkness, or other color characteristic of that person. And even though, as you can imagine, even though the race and color can clearly overlap, they are not synonymous, right? So color discrimination can occur between persons of different races or between persons of the same race or ethnicity. And I would say it's not a common claim that I've dealt with over my career, but it does come up from time to time. And it's something I think if probably know of the lessons that kind of come out of what our discussion today. I think this is a good example of the need to be sensitive to the perceptions of anybody who comes forward with a concern. And obviously, I think we all know this, and probably preaching to the choir, right? Someone comes in and say, I'm being discriminated against by my boss or my colleagues because my skin's too light or my skin's too dark or what have you. Not that any of us, I think, would dismiss that or reject it out of hand. But I find that over the years that the biggest challenge, and perhaps hopefully we can imagine that a number of you all agree as well, is more so in kind of cascading that mindset to both the frontline managers, mid to senior level managers, folks that are not trained in human resources or compliance, to the folks who, and this kind of gets, I think, weaving in our theme today of this unconscious bias and not even just unconscious bias, but kind of an conscious or unconscious inability to relate or to understand these sorts of concerns. And so someone who may be generally sensitive to race discrimination may find someone coming forward with a complaint about color discrimination to be trivial, and I think it thus falls to the folks that do the training, the folks that roll out the policies and hold the meetings, to really help people understand and kind of overcome those perceptions, those inherent biases that they may have, and recognize that just because you're not familiar with an issue or you don't recognize that as a problem, that obviously it can very well be for others. I think moving on to the next slide, please. And so this will again cover this a bit under the appearance policies as well, but religious garb and grooming, right? So there are a number of different aspects to consider. Certainly, harassment, someone who is subjected to disparate terms and conditions of employment because of their religion, because of how they dress, because of how they groom themselves or don't groom themselves. So you've got that piece, right? And of course, in addition to harassment, making sure that they're treated equally, given equal consideration for promotions, treated the same with respect to discipline and discharge. But then you also have the potential for, of course, an accommodation claim, and the need to accommodate sincerely held religious beliefs, practices, or observances, and certainly, one's clothing, one's grooming habits or practices can do fall within that, under that umbrella as well. I think that certainly accommodation of religious beliefs has garnered a bit more, quite a bit more attention over the last couple of years, and so we're not from an appearance standpoint, right? But obviously in the context of the COVID vaccines, we've all heard and I think talked a lot about accommodating religious beliefs, and so that was a belief about receiving a vaccine, but the concept is generally the same, right? In terms of does giving somebody whether it's an exception to a vaccination mandate or an exception to a dress or grooming policy, does that impose an undue hardship on or burden on the operation of your business? And I think everyone or many of you know that it's a slightly different burden than we see under the ADA. It's a little bit of a lower threshold, and it really amounts to more than a de minimis impact on operations or on your policies or procedures. When considering religious accommodation requests that relate to clothing, that relate to appearance, obviously consider their job, right? The requirements of their job, the clothing or grooming that is at issue, and then possible accommodations. And I've presented on accommodations quite a bit over the years. It's always a topic that I found to be particularly challenging, but one I think as much in this area as any other, where putting in the work when the request is received, doing your due diligence, documenting what the request is, particularly important, documenting the steps that you take to evaluate, investigate the requested accommodation, demonstrating that you're engaging in, although it's more commonly discussed, right, in the interactive process under the ADA, but engaging in that back and forth discussion with the employee, and then ideally, if at all possible, offering them some alternative, whether it's a different position, whether it's some relaxation of the requirement, or perhaps in some cases exempting them from the requirement. Certainly, there are many cases where that's not going to be mandatory, and there's also work that goes into kind of preparing for these types of claims, and being able to defend them in a way that is effective. So you probably heard us talk about it a number of times in the past, evaluating your job descriptions, as a regular part of kind of your due diligence, making sure that they're accurate, making sure that if, for example, a certain type of attire, certain type of outfit or clothing is required or not, or can't be worn, that those are all things that you're kind of building the foundation before the claim ever comes up. I had a challenging case with the EEOC a number of years ago involving the religious discrimination of somebody who was unable to cut their hair. He was a Native American, and it was his position, having had a dream about that his spirit ancestors came to him in a dream and told him he could not cut his hair. And so that was the religious justification for not cutting his hair. And in that case, it really came down to this individual worked around dangerous equipment, there actually was potential that hair of a certain length could get caught in certain machinery and pose a significant hazard. But that's not obviously the end of the inquiry, because then where I think in that case, the claim that came to us where the employer, I think, probably could have done a better job was really evaluating alternatives, whether it was moving to a different position or really just finding a way, to secure his hair so he wouldn't be at risk, whether it was under a hat, whether it was some other means. And I think sometimes what happened there really was kind of a short circuiting of that process, where the folks that were involved in the decision just were operating on assumptions like that this was the requirement, couldn't be done any other way, jumped directly to termination without really kind of building doing the necessary inquiry and evaluation that probably would have led to a different result. All right, moving to the next slide. So obviously, and I alluded to this earlier, another category within Title is gender or sex discrimination. But keeping in mind, as we put on this slide, that sex plus, that it's more than just simply so one's gender. As we've seen that sexual orientation is covered, recognized as covered, pregnancy, and obviously it's unlawful to harass a person because of their sex, including their sexual orientation, their gender identity, pregnancy. And obviously, this is an area where I think we're going to see a significant amount of litigation in the coming years. As society grapples with recent Supreme Court decision and a number of different issues. Again, I think this is an area where the law is hasn't really caught up to kind of changes in society as well. I think we can jump ahead to the ADA slide as well. So, like Title VII covers employers with 15 or more employees, and other than the religious accommodation aspects of Title VII, obviously one of the more significant aspects of the ADA, where it differs from other employment laws, is that you have both the prohibition against disparate treatment, against employment actions, promotions, demotions, terminations, but also that there is the affirmative requirement to provide reasonable accommodation to employees. On the kind of the non-discrimination portion, there is, I think, the lesser types of claims that we still see from time to time. Obviously, the most common is simply treating somebody differently because of they are actually disabled. But there are also claims, and I've had a few, not a lot over my career, but somebody who has a record of disability or a history of disability. So somebody who has been treated in the past, particularly these claims I tend to see more commonly with people who have been at or with their employer for a period of time and have undergone treatment, and so they have this quote record or history of disability. And then the one that can be particularly challenging are perceived disability claims. So someone who's not actually disabled would not meet the standard of establishing a disability, but is believed to be disabled by the employer, and as a result, perhaps it's not considered for a position or is terminated because they're believed that they can no longer perform that. Probably more so than any aspect of the ADA, these claims tend to be supported by comments made, again, by manager, often well-intentioned managers, but not always, certainly, supervisors. Again, that group of individuals that I talked about before, where I've always viewed as the ones that most benefit from solid training that educates them, about the laws, about their perceptions. Kind of, again, getting back to Ashley's point about people who are, because they don't fit the traditional perception of what somebody might look like or be able to do based on a condition that they have, or an injury, or some other condition that then there's this assumption they can't do it, and so they are perceived as disabled. So even though they may not be, we'll talk a little bit more, I think, about what that looks like in terms of the accommodation process. Yeah, you can step to the next slide. Thank you. Even two, I think, more cutting edge issues that I've seen more recently. One is obesity, and another is, I think, cosmetic. We're talking about appearance discrimination, is cosmetic disfigurement. So people who, the disfigurement is one that is cosmetic, meaning it doesn't impact their ability to do the job, right? But again, the hiring manager who doesn't want that person interacting with the public for out of fear of some perception or what have you. Obviously, that even if that person's disfigurement or issue is not actually disabling, that's where you have potential for a perceived disability claim. And then obesity, which I'll get into in a second, and discussion of weight, is an area where it's probably a good actually transition. I think we can maybe skip over real briefly the harassment slide and just go to the last one. I want to make sure we get a chance to cover. Yes, thanks. So I can talk about weight in here and obesity. I think it's a better context to do that. So at the heart of the slide, right at the center is appearance matters, and I chose that title intentionally. That it matters, and these are different matters of appearance. It matters to employers. It matters to the people who are affected by these policies, and these are all things, particularly tying it back to what I excuse me, I talked about at the beginning of my portion of the presentation, is the significant changes that I've seen over my career in terms of really, I think almost in each of these aspects. So whether it's, but particularly I think with dress codes, hair and grooming, tattoos, piercings, etc. When I think back to, just like Ashley, when I started my career and reviewed a lot of handbooks, and certainly still review policies to this day, usually in the context of litigation or EEO charges. The policies that I can recall reviewing years and years ago were pretty basic, right? And they were just, I'd say, pretty inflexible. Had a very clear, just must be professional, and must, and you even see some that kind of talk about traditional appearance or business-like appearance, and that gets to what Ashley was talking about, like what is a business-like appearance, and obviously the context is going to matter. How I dress, how Ashley dresses, versus somebody who works, in a tech startup, versus someone who works in a factory. Obviously, those are pretty basic, but I think within, I know many of our attendees today are in professional service environments or office environments, And so I think we're seeing a lot of change, particularly with respect to dress codes and hair and grooming. So I'm going to run through, share some kind of interesting cases and some considerations in each of these areas. So, dress code, obviously, I think for the most part, employers still enjoy a fair amount of leeway and latitude as far as imposing a dress code. And if you're talking about, people must wear, business attire, or, men must wear a suit and tie or something like that. But there are, I think, a greater number of limits or potentially exceptions that need to be, if not made, considered. On the extreme end, one case that I recall reviewing it in preparation for this and in past cases, where let's say you're in a business environment, right, and you decide you're going to require all female employees to wear pants, right? Now that's not going to fly, I would imagine, and would likely presumably be challenged. But in one case, in a correctional facility, there was a pants policy. A number of female employees filed not on gender discrimination grounds, but on religious grounds, claiming that in their religion, women had to wear a dress or a skirt. In that case, they lost. The employer was able to establish that there were legitimate safety and security reasons, to need to have to wear pants in the event of certain instances where tactical gear was required, and items that needed to be carried, I guess, in pants pockets or in gear that needed to be worn. So that is obvious, I think, an obvious situation where certain clothing or outfits can be mandated. I can't recall, outside of a unique contexts where I've seen a similar type of dress code, that is kind of gender necessary, might be create those sort of gender issues. But again, I mean, in hospitality, obviously requiring your servers to wear a certain outfit, in a hotel, in a uniform, I generally don't think, for the most part, the employers still have a fair amount of discretion and latitude to impose kind of general dress codes. You see in the yellow box there, makeup policies. I would certainly categorize in the very rare set of circumstances. I think in my entire career, I probably only once or twice had an employer that kind of had a policy that got into that level of appearance. And like the case, one of the seminal cases in this area was the Jesperson case, involving a server at a Harrah's casino in Las Vegas. It was a case that garnered a number of attention several years ago. And those of you that may or may not be familiar with the case, involved an appearance policy, with Harrah's personal best program, where bartenders were required to be well groomed. I think as the policy put it, appealing to the eye, certain fitness requirements, and then also the female employees were required to have their hair teased, curled, or styled, and to wear stockings, nail polish, and makeup that included lip color. Again, very rare circumstances, I think, where a policy like this is going to be used, let alone survive. But in that case, it was interesting that the court held that even though the requirements did not apply the same to men, the casino prevailed because the court found that these requirements didn't, as the court put it, unequally burden women, and there was a legitimate business justification for the policy. The only time this ever was something that I was asked to opine on was for a nightclub in a large city, which was looking to adopt kind of similar appearance requirements. I think, again, it's an extreme example, one that's likely not going to come up for the overwhelming majority of the folks listening today. But I think it does get to the point that there are, short of this type of requirement, that there may be legitimate appearance requirements that you can impose or on employees if there is, again, that legitimate business reason for it. Kind of moving, I guess, clockwise to maybe the 4 or 5 o'clock line there. The weight. Obviously, this is an area, I think, of particular importance, given the makeup of our country, the laws that are changing. Just to kind of orient everybody, there is no federal law that recognizes weight as a protected characteristic. Interestingly, there is one state. Usually, there always seems to be kind of, one state that will sometimes, and it's not necessarily the state that you would expect, right? California, or it's the state of Michigan. So within Michigan's Elliott-Larsen Civil Rights Act, it explicitly includes that as a protected characteristic. There are a growing number of cities that include weight in their municipal codes. Some in I believe in California, a couple here in Illinois. And I think, again, if you're faced with an issue, involving someone who's claiming to be discriminated against based on their race, particularly if they're in an urban workplace, in the city, as opposed to I'm not aware of any small rural towns that have protected it. Obviously, just best practice to verify, check your local ordinances to see if they've been amended to cover weight. In the state of Washington, the state Supreme Court has recognized obesity as a disability. And the thing to keep in mind, and what I'm really getting at, I should have clarified, is it's the question of whether obesity or weight alone is a disability. And so there are, certainly under the ADA, that in court, a number of courts have found obesity to be protected if and only if it's connected to or caused by an underlying physiological disorder or condition. And so that can really limit the application of the ADA to people who are claiming some discrimination based on their weight. That's the position that the Seventh Circuit, which applies here in Illinois and Wisconsin, reached in a case involving an employee of the Chicago Transit Authority. Second, Fifth, and Sixth, and Eighth Circuits have also reached this conclusion. Now, the EEOC takes a different position, and that is that obesity on its own, without any underlying condition, is protected. There is at least one federal district court that has agreed with the EEOC. Interestingly enough, it was I think the Eastern District of Louisiana, and this is certainly, I think, a position that they can and may well gain traction going forward in the years ahead. And so whether or not ultimately, someone bringing that sort of claim, can proceed or not, I tend to assume that if somebody goes to see a doctor, that there's a good likelihood, whether it's obesity or other claims, that I think the reality is that people, the doctors are often going to I think reach conclusions that agree with, in some cases, agree with the person who's seeking the treatment and find some condition that is connected to it. So I think for anyone who thinks like, well, we'll be able to avoid a claim, simply because there's no underlying condition, that's not something that I think is a wise approach. As I said earlier about, talking about if you're preparing for being able to respond to these types of claims, again, looking at your job descriptions, making sure that if someone, there are certain requirements that someone may or may not be able to meet, whether it's climbing to the top of a grain bin that's 100 feet off the ground, being able to enter a permit required confined space, and being able to fit into a certain area. I mean, those are, I think, probably rare examples, But even in that case, you can't assume that somebody simply because they're obese can't safely climb. There are, again, consistent with or similar to the makeup case that I talked about. There have been some cases where kind of strictly limiting or watching employees' weights have been approved. There's a case, again, involving a casino. In this case, it was one out of Atlantic City, where that sort of policy was upheld. But again, I think that's certainly an outlier. And I would also, again, reiterate the importance of kind of keeping in mind the potential for perceived disability claims, right? So a hiring manager who assumes that someone can't do the job because of their weight, maybe they make a comment, right? That's how so many of these cases get started, and training those people to recognize their conscious or unconscious biases or perceptions, and not to make those assumptions. Again, I think helping people recognize those things in the first place is particularly important. And just real briefly, even jewelry. I in my career, I've not had a case involving discrimination where jewelry was kind of the triggering policy or consideration, but I'm aware of at least, this, it does come up from time to time. There's a case I recall involving a person who was a Wiccan, who wore certain jewelry relating to her religion. She brought a claim against Starbucks, alleging that she was terminated because of the Wiccan jewelry that she wore, and as evidence of disparate treatment, pointed to the fact, I think, that coworkers who were permitted to wear crosses or Christian iconography, right? So again, I think in that case, it ultimately turned that was found not to be the reason that she was fired. There were legitimate, I think it may have been attendance or performance reasons, but again, even someone, what do you do with someone who's wearing a satanic jewelry or what have you? Kind of being mindful of that can trigger a Title VII claim. And before I turn it over to Ashley to finish and really dig into kind of the hair and grooming piece and the Crown Act, which I think really very, very much reflects kind of changing societal attitudes in the law, kind of recognizing things that it didn't previously recognize. It's just briefly to talk about tattoos and body art, and probably one of my all-time favorite cases, not that I worked on, but just that I'm familiar with, which involved a case involving a cashier who worked at a Costco in Massachusetts, who was hired in the late 90s to work at the deli. When she started working in the deli, she had 11 ear piercings and some tattoos, but no facial piercings. She was transferred about a year later, and because the company's dress code at the time prohibited the wearing of jewelry by any employee wearing food, so she had to transfer as a result of that. Around that time, she got her eyebrow pierced. She then continued to just get additional tattoos and piercings, and apparently cutting as well. And kind of around the time that as the policies were changing, and Costco further revised its dress code to forbid the wearing of any facial jewelry other than earrings. So no face piercings, no tongue piercings. This employee became a member of the Church of Body Modification. Apparently, I think at the time, at least according to the opinion, there were only about 1,000 members. And this church espoused that body modification and manipulation was a way for its members to strengthen their connection between the mind and body and ensure spiritual fullness. It's kind of somewhat reminiscent of, I think, other recent religious accommodation claims that we've heard about, kind of this mind-body connection. She was ultimately let go after refusing to comply with the policy. She filed an EUC charge. The case ended up going to litigation, and in that case, Costco, they company did prevail, and the court, I think, recognized that even if, and I think really didn't get into the sincerity of the religious belief, but assuming that her beliefs were held, she had a limited number, or really a limited thing that she would accept as an accommodation. And the court's conclusion was that would impose more than a de minimis cost on Costco to the impact of having somebody who had all those piercings on the company's image. So, will a case like that come out the same way now? I don't know. I think it's changing, but again, I think employers still do have a significant amount of ability to at least craft these policies, and it's really going to be about the implementation and your willingness to consider all the many different reasons that someone may not be able to comply, many of which are going to be legitimate, some of which obviously won't be. And it's really, I think, having a process in place to kind of sort through those requests, those reasons, analyze it, hopefully train your people to not make comments that would color or taint an otherwise legitimate process that you go through. So that's my part. I know I've been talking for a while, and I apologize. I'll turn it over to Ashley to cover the rest of the program.
Thanks, Aaron. So now we will be turning to the Crown Act, and which is the Creating a Respectful and Open Workplace for Natural Hair, is what CROWN stands for. And the CROWN Act in its various state and local versions, and I will expand on those state and local versions in the next slide, but just to give a brief overview, it expands the legal definition of race as a protected class to include traits that are historically associated with race, including hair texture and style. And so in the federal government, the CROWN Act passed the House in March of 2022, so March 18 of this year, and is now under consideration in the Senate. Now, the federal version of the CROWN Act is broader in scope than some of the state legislation. And so as a result, the federal version is called Creating a Respectful and Open World for Natural Hair Act of 2022. And the federal legislation's stated purpose is to institute definitions of race and national origin for federal civil rights laws, so like the ones we've been talking about in this webinar, that effectuate the comprehensive scope of protection that Congress intended to be afforded by those laws. And Congress's objective is to eliminate race and national origin discrimination in the U.S. And so if passed, the law would prohibit workplace dress code and hygiene policies that may show racial bias, and requiring employees to appear, quote unquote, professional by prohibiting afros, braids, twists, cornrows, locks, and other hairstyles or natural hair types that have been historically associated with race. The federal version would also make it unlawful for an employer to fail to hire, refuse to hire, or discharge any individual or otherwise discriminate against an individual's terms of employment based on their hair texture or hairstyle, where that hair texture or hairstyle is commonly associated with a particular race or national origin. And so this is the federal version, which is currently in the Senate. It definitely faces an uphill battle, but President Biden has certainly expressed his support for the bill. And so assuming it makes it through the Senate, it is definitely something on our radar and something to keep an eye out for. And then just turning next to where the CROWN Act has passed in state and local legislatures. And before we get into that, I did want to take a quick pause here and note that while many of the CROWN Act legislative findings, both in the Senate bill as well as in the various state and local findings, while they point to a history of race discrimination on the basis of Black hair and Black hair texture, I would be remiss if I did not also mention that this is not solely limited, right, to Black hair and Black hair textures, as there are other communities that have religious or cultural connections with their hair, including uncut hair or, untrimmed hair. I know Aaron has mentioned that, and I just wanted to mention it here again. And so not to forget about Native Americans, for example, or Sikhs or Muslims, where natural hair for them may include maintaining their hair in an uncut or untrimmed state. So also just wanted to make sure that we were thinking about, yes, Black hair and Black hair texture, but also other communities where hair is related to culture and representation of culture and religion. Here on this slide, we are able to see the status of state legislation before the flurry of legislation aimed at protecting natural hair. Some appellate courts had already applied the protection of Title VII liberally. So for example, going as far back as 1976 in Jenkins versus Blue Cross Metropolitan Hospital, the Seventh Circuit held that a plaintiff's EEOC charge sufficiently alleged race discrimination, where the plaintiff's EEOC charge stated that the plaintiff's boss denied the plaintiff a promotion because the plaintiff could, quote, never represent defendant with an afro, end quote. And so while Illinois now has its own Crown Act, Seventh Circuit employers in Wisconsin and Indiana should also be aware of their employees' EEO protections under Title VII. And then also just keeping in mind for Illinois that there are those Title VII protections and now these state law protections. And other courts have opted to take a more narrow approach. So in the EEOC, the Catastrophe Management Solutions, the 11th Circuit in 2016, so far more recently than that 1976 opinion from the 7th Circuit, the 11th Circuit reasoned that Title VII protects persons in covered categories with respect to their immutable characteristics, but not their cultural practice. And so the 11th Circuit upheld a race-neutral grooming policy that prohibited dreadlocks. And so while employers in the 11th Circuit, again, may not be subject to federal liability, as we can see from this map here on the screen, several localities in Georgia do have the Crown Act. So please keep in mind if those are where some of your offices are located or some of your employees are, that there may still be protections for those employees. And just to know, I know we are talking about dreadlocks and we are talking about appearances. And if it is the case that maybe some of those remnants are in your handbook, you're not alone. The U.S. Department of Defense back in 2014 actually enacted a general ban on Black hairstyles, including afros, twists, cornrows, and braids, and used terms such as matted and unkempt in its appearance regulations, as it was talking about some of those hairstyles. And so if that is the case, if it's still there, if it's in your handbook, not to worry. We are now going to turn to some best practices and ways that we can move forward, but also you were not alone in that. So I don't want it to feel like, oh my gosh, how could we not have known, when up until very recently, it was actually something that our U.S. Armed Forces was actively enforcing. So first, just thinking through employer liability. As Aaron has already mentioned, I'm sure a lot of you are very familiar with Title VII, so I won't, but just to orient everyone, the rules for liability will differ depending on whether the harasser is a supervisor. And so an individual will qualify as an employee supervisor if they have the authority to undertake or recommend tangible employment decisions that affect the employee, or the individual has the authority to direct the employee's daily work activities. And so as a general rule, employers are responsible for the behaviors of their supervisors because employers act, through their supervisors. And so anytime discrimination by a supervisor results in that alleged victim suffering a tangible employment action, such as being fired or quitting in response to intolerable harassment, or maybe they are demoted or not promoted or docked in pay, the employer would be liable for those actions. So for example, or the employer could be liable for those actions. So for example, if a supervisor has a racially motivated grudge against an employee, or maybe that supervisor has an understanding of what professional appearance looks like, and it does not include, locks or braids or twists or an afro, and acts on that motivation or understanding that that employee's appearance is unprofessional because of the way they wear their hair, and denies that employee a raise or, a promotion or anything else that they may have earned, the employer could be liable for the actions of that supervisor. So just keeping that in mind, and then looking at the unlawful harassing conduct of non-supervising employees or non-employees over whom you may have control, such as independent contractors or even customers on the premises. I know Aaron mentioned earlier that it's not a defense that the customer, asked for someone who maybe had straighter hair or fairer skin. Just highlighting that again here, you could be liable if you knew or should have known about that conduct or about that request and failed to take prompt and appropriate corrective action. Now, that being said, for employers, who do have robust policies in place and who are proactive, there are defenses to liability under Title VII. So here we see there's an affirmative defense available to employers that exercise reasonable care to prevent and correct, any harassing behavior. And, there's also a defense if the employee, once the employer offered solutions to that harassing behavior, if the employee unreasonably failed to take advantage of, those corrective opportunities, or even if the employee failed to, make the employer aware, those are, of course, defenses under Title VII. So in thinking about what it means to exercise reasonable care, what it means to correct promptly that harassing behavior, for those affirmative defenses, we turn to proactive steps and best practices. And so I know I mentioned earlier that as recently as 2017, 2018, the U.S. Armed Forces had these terms of unkempt and unkept as it related to Black hair, and actually prohibited locks and other natural hairstyles. Well, in February 2021, the U.S. Armed Forces did, in fact, remove their minimum hair length requirements and lifted restrictions on any soldier wearing braids, twists, locks, and cornrows to promote inclusivity. And so similarly, for employers who find themselves in that position of having language like that in their handbook, you might consider first reviewing your policies to see, what they are and if language like that exists, reviewing the dressing and grooming and hygiene policies, and then making sure that they don't run afoul of the Crown Act. And, as we're thinking about disparate impact claims, which I know Aaron discussed earlier, even to the extent, right, that your handbooks and your grooming policies are not using these terms and are not using that coded language, surveys have found that Black women are made to be more aware of corporate grooming policies, such that they receive company grooming policies at higher rates than their counterparts. And Black women are 1.5 times more likely to be sent home from the workplace because of their hair. And so the second step would be ensuring that all employees are treated equally, regardless of their race or characteristics associated with their race, such as hair texture and hairstyle. Again, and thinking through that affirmative defense to liability, it would be prudent to not only establish those anti-harassment policies and complaint procedures, but also ensure that there are multiple avenues for reporting the harassment and unwelcome conduct. So if it is the case that an employee's direct supervisor is the one doing the harassing or making those comments about the hair, or who potentially has those biases about professional appearance and what it may look like, it is imperative that that employee has more than that supervisor as a means of reporting and as a mechanism of making that complaint. And so employers would be well advised to set up a mechanism for prompt, thorough, and then impartial investigations into any alleged harassment. And so as soon as management learns about that alleged harassment, making that determination pretty quickly about whether a detailed fact investigation is necessary. So for example, if the alleged harasser does not deny the accusation, then of course there would be no need to interview witnesses, and you could move immediately to the next step in the process, which would be determining what the appropriate corrective action may look like. But if a fact-finding investigation is necessary, then of course launching it as soon as practicable and immediately if at all possible. And consider, as you're launching the investigation, simultaneously consider whether it's necessary to undertake intermediate measures before completing the investigation to ensure that further harassment does not occur. So for example, an employer may consider making schedule changes so as to avoid contact between the parties, or transferring the alleged harasser, or placing the alleged harasser on non-disciplinary leave with pay pending the conclusion of the investigation. And I just want to note here that as you're thinking about what those intermediary steps may be, the complainant, so the person, complaining of the harassment, should not be the one who is involuntarily transferred or otherwise burdened. If we're talking about shift changes, schedule changes, or any sort of changes like that, because Title VII does have an anti-retaliation provision, and such measures, where they are the ones who are bearing the burden of those intermediary corrective actions, could constitute unlawful retaliation. So as you're thinking about those potential intermediary steps, just thinking about the impact that they may have on the complainant, on their workplace experience, on their ability to access promotions, pay raises, and things like that, and just their general terms and conditions of employment. Another best practice as we're thinking through the investigatory process would be ensuring that the individual who conducts the investigation is objective in their gathering and consideration of facts. And so one thing that would be really important to point out is making sure that the alleged harasser does not have supervisory authority over the individual who conducts the investigation, and making sure that the alleged harasser does not have any direct or even indirect control over that investigation. I know Aaron has said appearances matter, and here is where those appearances, do come into play, where employers should make it clear to both parties, that they will undertake immediate and appropriate corrective action, including discipline if necessary, and whenever the employer determines that harassment has occurred in violation of, your in-house policy. And so again, making sure to inform both the complainant and the accused about those measures. If it's determined that there is in fact harassment, having remedial measures to correct the effects on the employee and ensure that the harassment does not, occur again. The remedial measures don't have to necessarily be the one that the employee requests or prefers, so long as they are in fact effective. And so when thinking through disciplinary measures, if that is necessary, keeping in mind that, if the harassment does not stop, the employer could be found liable because they've taken that first step, which is identifying it, but not necessarily that second step, which would be rectifying it and preventing it from happening in the future. And I say all of this knowing that there will certainly be concerns about overly punitive measures, that may subject the employer to claims like wrongful discharge, and what is and is not appropriate. in this instance. And so, it's a balancing act with competing concerns. And so some factors to think about are what's proportional to the seriousness of the offense. If the harassment was minor, such as a small, off-color remarks, by an individual who doesn't have a prior history of similar misconduct, then maybe it's the case that there's counseling or, just a warning. And maybe that's all that's necessary. Maybe you have an on-site trust building day where, there's training or just additional conversations that are had. But on the other hand, if the harassment was severe or persistent, perhaps you might consider escalating. But just keeping in mind that any remedial measures, of course, should be proportional. And at the end of the day, they should not adversely affect the complainant. So the person who actually came forward in their complaint should not bear the burden of any of those corrective actions that are taken. Of course, saying all of that, knowing, right, if you are engaging in diversity, equity, and inclusion training, they will be required to attend because everyone is being required to attend, but just making sure that as we're thinking about shift changes, schedule changes, job changes, that the person who is complaining is not bearing the brunt of any adverse effects. And so again, as we're looking at proactive steps and best practices, before they even become, an employee, there is the recruitment and hiring process. And who ultimately receives employment opportunities is very much so dependent on how and where employers are looking for candidates. And so accordingly, Title VII forbids not only recruitment practices that purposefully discriminate on the basis of race, but also practices that disproportionately limit employment opportunities based on race. And those requirements are not related, to the job or to business needs. So for example, when we think about recruiting from racially segregated sources, I know we don't really think of our, neighborhoods being potentially racially segregated, but being located in Chicago, which has a deep history of redlining, certain neighborhoods are indeed racially segregated, as well as certain schools and certain religious institutions and the networks that are associated with those. And so in thinking critically or just thinking about the recruitment process, even if it's not intentional, it can lead to hiring that simply replicates the patterns, of racial segregation in our society. And so thinking actively about other places to recruit. For example, of course, you want to go to your local bar association. Well, I, as a lawyer, would want to go to my local bar association, but perhaps there are other diverse areas of recruitment. Maybe you are located in a state or a city that has a historically Black college or university, or maybe you are located, or maybe your particular area of employment or particular practice has trade associations or other groups that cater to diverse persons in that practice or in that work group, and thinking through, maybe reaching out to them and perhaps placing your job ad in those publications as well. And then as we are moving past the recruitment phase and into the hiring phase, when making hiring and promotion decisions, it's important to apply the same selection criteria to persons of different races and to apply them in the same way, which means, giving the same weight to each criteria for each person. And any reasons where people or persons are not moving to that next step in the hiring process or that next step in the promotion process, making sure that selection decisions should be credible and supported by the evidence. For example, I know we started off asking, what does professional appearance mean to you? We have not gotten to the last slide of the webinar. And if you have not seen my bio, I am a Black woman with natural hair. And so when I think about professional appearance, the first thing I think about is a woman. The second thing I think about is a Black woman. And then for me, her hair is not straightened because I don't wear my hair straightened. I say all of that to say my definition, or what readily comes to mind of professional appearance, is in the minority. I am not in the majority in most workplaces across America, and that's okay. But I should also be challenged, and I am constantly and continually challenging my bias and understanding of that definition. And I say all of this to say, when we are thinking about the reasons for selection decisions, if the decision is based on the idea that, hey, I want someone who I can relate with, and I couldn't really relate with this person, well, challenging that idea. What does that mean? Were you unable to relate with them because they didn't come from the same social circle? Were you unable to relate with them because they didn't have the same appearance as you? Like, just really questioning those ideas and making sure that it's about the criteria for the job, you know, whether it be that they have sufficient amount of experience, whether it be, was their resume up to date? Those hard things that we think about when we think about who's qualified for a job, and maybe not so much relying on some of those softer criteria like, well, you know, I picked person A because they go to the same country, they belong to the same country club as me, even though perhaps person B does not belong to that country club and may be equally qualified. And I say all of this to say, you know, nevertheless, these educational requirements and other requirements are obviously going to be important for certain jobs. For example, graduation from medical school is going to be required to practice medicine. Of course, you want a lawyer who has graduated from law school and who is barred in the state of practice. However, think as you're thinking about these requirements, as you're placing them on the job, please ensure that they are job related, and that they are not, you know, just what might be the utmost desired, you know, because such requirements may run afoul of Title VII if they have a disparate impact and they exceed what is needed to perform the job successfully. You know, the Supreme Court stated in one of its earliest interpretations of Title VII, quote, that history is filled with examples of men and women who rendered highly effective performance without the conventional badges of accomplishments in terms of certificates, diplomas, or degrees. Diplomas and tests are useful for servants, but Congress has mandated that the common sense proposition that they are not to become masters of reality, end quote. And then just a last note on these terms and conditions of employment and supervisor training. Title VII requires an employer, once it's aware, you know, that a religious accommodation is needed to accommodate an employee who has a sincerely held religious belief or practice or observance that does conflict with any appearance standards or requirements, unless doing so would pose an undue hardship. And so when an employer's dress and grooming policy or preference conflicts with the employee's known religious beliefs or practice, it's required that you make an exception to allow that religious practice unless doing so would be an undue hardship. And as you think about training your supervisors, it's important to note that the employee does not have to use any magic words to make the request. They don't have to say accommodation or Title VII. And so to the extent that you have employees who maybe you work in food service and they're unwilling to trim their hair because of a religious reason or a cultural reason, right? And that employee says, I can't trim my hair because my culture doesn't permit me. That may in and of itself be sufficient to trigger that interactive process between the employer and the employee to see if there's an accommodation or to see if there's anything that can be offered to the employee. Now, that being said, Erin has highlighted some great cases where it's not open and shut. The employee has asked, therefore you are obligated to oblige. But of course, engaging in that process and really thinking about whether it is at all possible. And so with that being said, I think I will turn it back over to Erin for closing remarks, as well as I haven't been watching the chat. I'm not sure if we have any questions.
Yeah, I see. I think just a couple. We can jump to those in a second. Yeah, I thank you for your thoughtful commentary and perceptive recommendations, and thank you for accepting my follically challenged self, being open to that. Right. It takes all kinds, including those of us without any hair. Um, hopefully, you all, I see a number of you have stuck around, so thank you for that. We kind of laughing as we always, Ashley and I often present together and always go into these thinking we're going to run short of time. We always end up going over time, and I think that probably speaks more than anything. Maybe the longer you've been in practice, the more you say, even when you're attempting to be brief. But hopefully we still have another 5 programs left this year. Good, particularly important one coming up next month on wage and hour. We'll be getting into ADA compliance, focused on websites in September, and then getting into ending the year with a recap of year 2 of the Biden administration. So hopefully you all will continue to join us for those. I'm just looking to see if we have any chat, any questions. Actually, I'm not seeing. Oh, here we go. Let's see. I don't think we do. I think we're all. I think we are without any questions. So, not going to assume that we answered them all. So, if anybody does have something that they want to talk to us about, or any of the other folks in the L&E practice group, just let us know, and we'll either do our best to answer them or put you in touch with the person who can. So you see our contact information on the screen. So again, please don't hesitate to reach out, and thank you all for your time today. Thank you for your patience, and have a good rest of your week.